Lords, my lady.
Ms. Townsend, yes.
In this appeal, we are confronted with what is essentially a single issue of law. Did the EIA directive require the County Council as planning authority to assess the environmental impact of the combustion of fuel on the climate before giving development consent for the commercial extraction of crude oil? Your Lordships, your Ladyship has our written case at page 144, CV 144, and I'll be referring to it from time to time as I go through my submissions. I will make these under 7 heads after a brief introduction. The first 4 heads relate specifically to the relevant legislation which is before the court. I'll first take a bird's eye view over the EIA legislation, then look at the project in a bit more detail, then at the phrase indirect effects, which are not defined, before looking at the principles which govern questions as to the adequacy of an environmental statement. Once that task is done, I'll go through the process that was followed in this case by my client, the planning authority, and some of the cases and documents which haven't otherwise been referred to, our position on what's relevant and what's not, before concluding as against the 4 grounds of appeal, largely returning to what is said in our written case. My Lords, my lady, properly understood, this is not a climate change case, but an EIA case, as has already been made clear. It turns on the interpretation of what are ordinary words in their particular legislative context. Those words apply to impacts of all kinds. No distinctions are made are made for climate impacts. And my learned friend, Mr. Hahn, says you need to understand the climate in order to apply those words or interpret those words correctly. I hope it's not too flippant to answer. We submit you need to understand the EIA directive and its purposes in order to understand the meaning of those words and their effect. As for what is known and not known about those combustion emissions, it is known that combustion will occur only once the crude has been sold, sent to a refinery, processed, distributed, and resold any number of times in the international market for petroleum products before it is finally used as fuel by myriad different actions. That fuel will form part of the international supply, indistinguishable from that from many other sources. More importantly, although we agree that the combustion event is inevitable, the extraction project, which we were required to assess, could take place and be operated successfully without it. It is complete at the point where that crude is sold. The emissions...
So what? I mean, it's the effects we're interested in.
Of the project?
Yes. So the effects are going to occur after the project taking place, but I don't understand the point you're making.
As I develop my submissions,
right.
I will explain the role that understanding the project and its scope has played in ascertaining what are genuinely effects of that project.
Thank you.
The emissions will occur at some point in the future, and while an estimation can be made of the potential quantity of carbon dioxide equivalent gas emitted, having regard to the scale and longevity of the extraction project, nothing is known about where, when, or in what circumstances they will occur. More importantly, perhaps, nothing can be known. Those facts cannot be known at the time that the assessment is said to be necessary. As we set out in our written case, we submit that the Court of Appeal majority decision should be supported, but it must also be acknowledged that a large part of Mr. Justice Holgate's analysis was explicitly endorsed by the senior president in his leading judgment. We submit it deserves specific approval in those respects. The difference between first instance and Court of Appeal decisions lies in the treatment of the question whether the emissions are indeed effects of the development as a question of law, Mr. Justice Holgate's point. Having held that it is a question of fact and evaluative judgment for the planning authority, not a question of planning judgment, not a question of fact and evaluative judgment for the planning authority, the Court of Appeal was scrupulously careful not to decide issues which do not arise on the facts of this case. And we submit that the Court of Appeal were right to do so for the reasons the senior president gave at paragraph 67, which is at page 384 of the core volume. And if the Lordships, your Ladyship, have that in front of you, I don't need to read the entire paragraph out, but 5 lines down, I draw attention to the phrase, in those circumstances, to require their assessment is not a question we have to decide. And it can be seen from the senior president's preceding analyses, as your Ladyship have paragraphs 60 to 66, that the judgment is deliberately faithful to the specific question they had to decide on its specific facts, namely whether this was a conclusion to which the planning authority was entitled to come. Yes, it was. It was neither irrational nor an error of law.
May I ask, in relation to the questions which you said can't be answered, I understand the council may have difficulty answering some of those questions about when and where this oil may be burned and where it may be refined and so forth, but are these matters that the second respondent can assist with?
No.
And wasn't required to?
No. Couldn't, because of the nature of the project.
I see.
The crude is sold.
Yes.
It's sold to a refinery, which is itself an EIA project, and thereafter it becomes part of first of all, it's part of the international supply of crude. It goes split up.
It doesn't
perhaps
matter.
Not all to the same place.
The question is the relevance of all these matters. If you know the effects are going to happen, where, when or how, unless you point out some way in which it's material, at the moment I don't see it's material.
We need to remember that we're looking at effects on the climate.
Yes.
And the greenhouse gas emissions are an indicator of an effect on the climate. But the EIA process is about much more than simply gathering data about the worst case scenario of an impact. And I'll, as I say, develop my submissions on that point. So to my first heading, the EIA legislation. The directive and regulations impose a series of requirements as to the process for the determination of planning applications, and they govern the decision to grant planning permission, the subject of this JR, of course. Unlike the Habitats Directive, but similar to the Strategic Environmental Directive, Assessment Directive, forgive me, the EIA Directive does not require a specific outcome to the process. It prescribes. In other words, it is neutral whether permission is granted or refused, provided the process followed by the decision maker is lawful. And in answer to my learned friend, Mr. Hahn, of course the EIA directive has a purpose and a value, but the important point of distinction from the Habitats Directive is that it is neutral as to the outcome of the process and whether or not permission is granted. It is not in that sense, protective of the environment in the same way as the Habitats Directive, the Birds Directive are. Now, the process involves 3 key stages. I've squeezed my learned friend Mr. Hon's 5 into the final 3. I'll go through them one by one. The first is the provision of information by the applicant to the decision maker in the form of the environmental statement or the environmental impact assessment report, to use the language of the directive. But a little more detail on this stage. An applicant may ask for a scoping opinion, as happened in this case, under Regulation 15. They may only do so before making their application for planning permission. And if a scoping opinion is provided within the relevant timescale, there is no appeal to the Secretary of State on its content. If provided, the environmental statement must be based on the scoping opinion. That phrase taken from Regulation 18. Would it be helpful just to go to Regulation 18? It's within the I've got it tabbed, the 3rd tab of the authorities bundle at 1274, and Regulation 18 itself is at 1284.
Starts at 1283, I think.
Yes, I'm grateful.
At the bottom, yeah.
Obliged for that. And at Regulation 18.4a, where a scoping opinion or direction has been issued in accordance with Regulation 15 or 16, it must be based on the most recent scoping opinion or direction issued. And it is common ground that this ES was based on that original scoping opinion.
Well, how can it have been based on that when that recommended that they should take into account Scope 3 and they decided not?
Yeah, the answer lies in the breadth of the words "based on," and it's a point that was momentarily taken at first instance, but not pursued further. And it's now common ground that the ES is firmly based on the scoping opinion, not least because it specifically addresses that request and explains why it's not following it. So at this stage, the ES is provided. It needs to be based on the scoping opinion. What's the job of the planning authority? Does it have any powers? Absolutely it does. The planning authority will review the ES, and if and only if it is of the opinion that more information is needed, it may require more information to be provided. That is Regulation 25, which is found in this rather uncomfortable supplementary bundle, which contains documents that were referred to in our written case but didn't make it into the original bundle. So if your Lordship have supplementary bundle, the supplementary bundle, and go to page 21 of it, you'll find Regulation 25. And I touch on it just to flag up the condition that subject to which the planning authority has a power to obtain more information, set out in the 3rd line of that sub-regulation. So the second stage of EIA is consultation. consultation on the information provided, and if further information is provided, then consultation on that further information, which is one reason there were 3 consultation events in this case, although I'm bound to say I'm not absolutely clear whether that was material voluntarily provided or provided pursuant to a Regulation 25 request, because often responses to consultation prompt a discussion between developer and the authority over the voluntary provision of additional clarification material. So further information may fall into one of 2 categories. It may be that which is required to be provided by the authority under Regulation 25, or it may be that further clarification or even a slight alteration to the project is put forward on a voluntary basis. And
So
that
what
all forms part of this consultation process. I'm sorry, my lady.
And roughly what form does this consultation process take? Is it just that the environmental statement is put out there, or does the council sort of wrap it up in some kind of description of the...
Yes, the answer to that is found in Regulation 19 of the Development Management Procedure Order. And I believe that the environmental statement is required to be on the council's website for a period. I think it's 30 days plus. But the reality is, it's not, the reason that period is given is that no decision can be taken on the application till the end of it. And the reality is the environment statement is on the website until a decision is taken on the application, which can be anything up to a year or more.
But presumably, if the council takes the view that the Scope 3 emissions are not an indirect effect, then any responses to the consultation document from members of the public saying, how is this going to affect climate change? What are you saying about this and climate change, would all be regarded as irrelevant to the planning permission decision.
They would be regarded as irrelevant. No, I don't think so. That happened. So let's go back a stage, if I may. The application is received, and there are requirements as set out in Regulation 19 for notification, for putting notices on the site, and indeed in EIA cases for sending a copy of the ES to statutory consultees. So that is the first step, and then when responses to consultation come in, and there were many hundreds of responses to consultation in this case, some supporting, quite evenly balanced between support and objection, and the greenhouse gas emission issue came up and was reported to members when the planning decision was taken. It is part of the decision-making process. It is not irrelevant at all. But I don't think you've answered your
would say that if such representations were made, that the local planning authority would be potentially entitled to take those into account?
It's required to take them into account if they touch on material considerations for the planning decision.
I just don't understand that. But suppose the council had said, right, we're going to refuse planning permission because despite the fact that we've agreed that these are not an indirect effect, we're nonetheless so concerned about the Scope 3 emissions that we're going to refuse permission. You think that would be a lawful, on your case, that would be a lawful decision for the council to come?
Yes, if it reflected the duties, the legal duties and the policies governing the planning decision. Yes, it's a balance of material considerations. The planning decision is a balance of material considerations, a key one being the climate change policy of the government, and that balance takes place in the light of the information provided in the EIA.
But you've said to the developer, we don't want any information about that. So how can it then be a material consideration?
What we've said is we don't need it to be assessed within the EIA process.
But it's still a material planning consideration, is it?
The climate change implications of hydrocarbon development are material considerations. It's clear that they are from the way in which national policy and development plan policy is framed. And it's within that policy that the planning authority were told by government and within its own development plan to give weight to the benefits of hydrocarbon, of all mineral extraction, of which hydrocarbon extraction is one. I do intend to really drill down into this. I'm hoping that my
just to get the structure clear.
Yes.
And presumably, if consultees are not happy with the position initially adopted by the council, they're entitled to make representations to try to persuade the council to change its mind, to say that downstream effects are indirect effects, and the council will have to assess that, wouldn't it?
Indeed, and it is a point I had hoped to convey, that that in this environmental statement it was explicit that certain matters that had been requested were not going to be assessed, and that was available for statutory, including the Environment Agency, and non-statutory consultees to comment on, and some members of the public did indeed comment on it. And then because EIA is an iterative process, it's perfectly possible then for the planning authority to say, you know, you were right. I'm now of the opinion that this ES is deficient, and I will now serve a Regulation 25 notice.
But that, you say, is all part of their evaluative judgment as to whether this is an indirect effect or not?
Whether it's a likely significant indirect effect of the project.
No, whether it's an indirect
climate,
effect or not.
Of the project on the climate. Yeah.
Well, let's see.
Effects, one of the difficulties of the way in which this is framed by the appellants is that effects don't float free of the thing they are an effect of. So we'd invite the court to focus on the fact these are effects of the project.
But you're saying that the fact that the council, in their review of the environmental statement, agree that there is no need for them to have any information about the Scope 3 emissions that would be caused by burning all this oil that's going to be extracted, that is not determinative of them later refusing permission on the grounds that the Scope 3 emissions are going to be too damaging to the climate?
Well, I can see how, in a rationality argument, that would be difficult for them to do. And it's also a very hypothetical question, because that would require a different policy context to that which we have, and a different decision which isn't before the court. So I have real difficulty addressing that just at the moment. Perhaps we can come back to it when I've laid a bit more of the groundwork about the way EIA works and also what happened in this case.
Certainly for my part too, I'd welcome your assistance when you get to it on the impact of inclusion in Schedule 1, paragraph 14, of the extraction of petroleum and natural gas for commercial purposes where the amount extracted exceeds a certain level, which I understand, if is accepted, this project will do.
At its peak, yes. It's just in the category, yes.
It's in or out?
Yes, exactly, yeah.
And it's in?
Yes. Absolutely. So, the three-stage process: provision of information, consultation on it, and possibly supplementation of that information. And then the third stage, examination of the information and integration into the decision. This is Regulation 26, which is in your in the bundle, the core volume, at page 1285, which sets out the specific requirements of the planning authority once the information is before it. And so, having outlined that process,
I beg 1285. I'm sorry, I'm just a little bit behind. Thank you. Yeah. Yes, thank you.
So, having outlined the process very briefly, I turn to the principles governing the approach to interpretation, which the Senior President outlined at paragraph 15, which I don't need to turn to. I'd really like to make progress, but we quote them in our written case at 95 without the supporting authorities. We do suggest that those are well established and uncontroversial. And just taking one of them, we focus on the need for a broad and purposive approach. No difference between us and the appellants there to the interpretation of the legislation, but it must always respect the words actually used. A few words on climate. Although it achieves more prominence in the directive after the 2014 amendments, and you have a full copy of the 2014 directive in the supplementary bundle, I don't need to go to it. The same language is used for the EIA of effect on the climate as is used for any other receptor, and that is, I understand now, common ground. Moreover, the climate has been, ever since 1985, the very first EIA directive, one of the factors listed at Article 3 and what is now Regulation 4.2. It is the EIA process, that three-stage process, which must assess in an appropriate manner, using the words of Regulation 4, the effects of the project on the climate. So the question arising under Regulation 4.2 is whether that overall process, including the planning authority's decision, undertook that assessment in an appropriate manner. Before leaving this heading, I've got a few absences for your Lordships, your Ladyship. None of the Court of Justice cases on EIA addresses climate change. None suggested as a special case meriting a different approach to interpretation. None requires the assessment of impacts of the product of development sold on the open market. None. None hold that it's a question of law whether an effect on the environment is or is not an effect of the project in hand. In every single case, provided the project itself and its operation are correctly identified, the scope and content of the assessment and whether it meets the requirements of the regulations is for the planning authority alone to determine, subject, of course, to Wednesbury review. Every single case. I hope I can move on to the project at this point. I'm running just a little behind time, but the questions are very much valued. I have 4 key submissions to start with. Project is defined, Article 2 of the directive. I leave it to another time to go there. Project The project is the key in my submission. It is only where a project is involved that EIA is required. And I know my learned friend, Mr. Elvin, is going to touch on the relevant jurisprudence on that point. It's only where a project is involved that EIA is required. And so I won't say more in order to respect the time constraints. Third, the EIA must extend to the use or operation of the project once constructed. The EIA must extend to the use or operation of the project once constructed. And fourthly, where consent is sought for one part of what is in truth a larger project, as that term is defined in the directive, the EIA must extend to the likely significant effects of that larger project. That's the project splitting line of case law with which I'm sure your lordship are familiar. Now, in the courts below, it was common ground that the project did not extend beyond the extraction of crude oil. That's paragraph 95 of Mr. Justice Holgate, and again at 122, page CV 442, which, in the interests of time, I don't go to. The senior president essentially endorsed Mr. Justice Holgate's view on that point, as can be seen from 32 to 33 of his lordship's judgment. It may be worth just looking at that, please. So it's in the losing my tabs. That's 375 to 376.
Yeah.
And concluding at 35, it cannot be said that Mr. Justice Holgate adopted too narrow an understanding of the concepts of the proposed development and the project. And
both this judgment is just bedevilled with these multiple negatives. It's impossible to say that something is not something. But what is...
perhaps because his lordship was not treading on the toes of the decision maker and instead supporting their right to make the decision that they took. At 33, I would like to read out from 7 lines down. References to the purpose of particular developments in the legislation and in the authorities should not be misconstrued in the way that the appellant did. Here, the extraction of crude oil for commercial purposes was the essential content and character of the proposed development. That was the project. The ultimate use of the products generated by the subsequent refinement of the crude oil was not part of that project, nor indeed was the refinement process itself, which would be in its own right a separate and substantial industrial activity carried out for profit by the companies concerned, nor were the distribution and sale of the refined product, which would also be separate commercial activities.
That's all very well, but the question is whether the burning of the oil is an effect of extracting it or not. And the fact that the intermediate steps are not part of the project doesn't answer that question.
Perhaps not in and of itself, my lord, but as the case law suggests, it's highly relevant. Those intervening steps and the degree of the connection is a highly relevant question.
I can see they could be, but when it's accepted that the end consequence is inevitable, I find at the moment it very hard to see why the intervening steps do matter.
Understood, noted, and I'll try to address that obviously as I go through. Page 377, and I'm just going to flag it for your lordships and your ladyship's note. 37 to 38 was his lordship's conclusion, what the consequences effect of his finding on the project. Indeed, I'm going to read from the first paragraph, first sentence of 38. It is therefore unsurprising, indeed essential, that the legislation for environmental impact assessment explicitly and consistently requires only the assessment of effects of the proposed development or of the project. Now, perhaps hopeful here, my Lord Richards would be assisted by looking at the definition of project in the directive itself, because the way project is defined is it's the bit of a development that is the physical intervention in the surroundings. And so we have Article 1 at page 1266. I'm looking, I'm not sure I've got it right.
Got the right reference?
No, I think, sorry, it's not there. It's,
Okay, 1266 is Article 1, I think.
I'm really sorry, I've got my pages wrong.
Are you looking in the first of the directives or the second?
The first one, and it's at 1232. I do apologise. I didn't intend to go to this, but I think in the light of the Lord Richards' questions,
I
if we
think
look at...
I think it's Lord Leggett.
Oh gosh, I'm so sorry.
I'm sure Lord Richards will be interested in the answer.
May that be my only error. I do apologise to both, your Lordships. Project means the execution of construction works first, and as applied here, other interventions in the natural surroundings and landscape, including those involving the extraction of mineral resources.
That's what we're concerned with, isn't it?
I'm sorry?
But that's what we're concerned with.
Yeah, indeed.
It's extraction.
And exactly, it's the works of extraction that is the project, and the crude oil that comes out is the end product of its sold, but it is not itself the reason that the development is. It falls
Sounds like a sort of piece of medieval
directive.
sophistry to me, this.
So to go back
You
to
extract the oil and then you sort of blank out what it's going to happen to it afterwards.
I thought
you
you
don't
might have
know.
a more limited purpose, which was that in paragraph 33 of Senior President's judgment, it was said this morning that he was wrong in what he said in the last three sentences, and I perhaps wrongly myself understood you to be meeting that point.
Yes. Well, we of course say he was entirely right in what he said.
But it was submitted this morning that he was right to say that the extraction of crude oil for commercial purposes was the essential content and character of the proposed development, and then wrong in what he subsequently said. And as I understand it, you say he was right in what he said,
yeah,
by reference to the definition of the project in the directive.
Indeed.
Is that right?
Indeed, and right to consider effects of the carrying out of the project, including its operation, which is this process of extraction. Turning to Lord Justice Moylan's judgment, in my submission, it reduces the clarity of the position that had previously applied, in that he found that the oil is the project, and the relevant outcome, therefore, is the use of the oil. Lord Justice Moylan's judgment is on this point is at 128 of the transcript and 403 of the bundle.
So paragraph
128.
128, thank you.
And
well, the penultimate sentence extraction of oil for commercial purposes, that is the project.
Yes.
Is there much difference between that and what you're submitting as the project here?
It's His Lordship's focus on the oil for commercial purposes, and indeed what he understood the commercial purposes to refer to, and that's where Lord Justice Moylan fell into error. It's our submission that his finding at that point. Just if I can ask your ladyship to come with me on this sort of submission. It's that finding and his emphasis on what was his view of those commercial purposes that led him into error. So he was wrong, we submit, to extend the project to those various commercial events accompanying the crude oil as it is bought and sold and travels, so to speak, down the stream. He stretched the concept of the project far beyond what the directive's concept of what a project is. In his treatment of the oil as effectively the project, and the commercial purposes being those that occur downstream. In contrast, we submit the senior president understood correctly the meaning of the phrase commercial purposes, and specifically held that the project did not extend to the downstream sale and use of the refined product to the development, in that passage that I just took your ladyship to.
Justice Moyle is not saying that the downstream sale is part of the project.
Well, he's saying
it would be ridiculous to say that. It's obviously not.
He's saying that the commercial purposes the commercial events that occur downstream
are the
purpose of the project, whereas it's the commercial purposes, as we say in our written statement, are those of the extractor, not the refiner, and certainly not anyone else downstream. The commercial purposes that are referred to are met when the oil is sold. They have nothing whatsoever to do with the downstream events, which are, let us face it, the cause of the greenhouse gas emissions. It's those downstream events, and whether they involve a net increase in greenhouse gas emissions, that are the cause of the impact on the climate.
May I ask you in this context, just to go back to paragraph 14 on page 1247, because I am puzzled by this, where the expression is the extraction of petroleum for commercial purposes.
I'm so sorry, I
do beg your pardon.
With you.
CD 1247, I think. This is where the...
Yes.
This is Annex 1 to the...
oh, yes.
Paragraph 14 at the top, I think, is the source of the regulation.
Indeed.
As amended. And what puzzles me about this is that if one isn't concerned here with effects, indirect or direct, which include the combustion, why is it included in these terms? Because it might seem a little odd to include this in the light of what we've been told about the extracting process itself producing very little by way of emissions.
Well, this is a description of a project which has myriad significant environmental effects on amenity, on potentially landscape. It's a major intervention into the local countryside, a sufficiently substantial project in construction terms, as well as in terms of the product it produces, that it deserves it to be included in the EIA directive. I don't think it is said against us that the only reason this is here is because of the downstream greenhouse gas emissions of the product of the development.
But in terms of an EIA assessment, would not the burning of the oil, which is defined in these terms, if that is what's likely to happen to it, constitute an indirect effect?
Well, we say absolutely not, in the same way that if you consent a major factory, you don't assess the impact of the use of the products that factory sells. The effect, the greenhouse gases we're talking about, and it's quite easy to forget this because climate change is such an important issue with which we are all concerned. But the greenhouse gas emissions we're talking about are caused by the combustion event, by the activity that led to that combustion. That's the cause of those emissions. The project, one might say that those carrying out the project have a moral obligation to consider those downstream emissions, and it may be they should report them under their company's activities reporting process, but they only do so voluntarily because they are Scope 3 outside the control of the operator of the site.
But perhaps another way of putting my Lord Kitchen's point is that they've included climate here now deliberately in 2014, and it's difficult to imagine a project of whatever size and whatever type, which potentially has a significant effect on the climate if you limit effects in the way that you're proposing. So that by saying that it's important to have a look at the effect on the climate, they must have been thinking about indirect effects extending beyond what immediately happens on the development site, because one can't imagine anything of whatever size affecting the climate in that sense. So why bother putting the word in there?
So a couple of points there, milady. First, that climate was a factor in 1985, so nothing changed in 2014, save a reflection of the increased importance of climate as an issue. But that can't change the meaning of the words indirect effect. Had it been intended in 2014 to cast the net more widely than was the EU's jurisprudence on effects of development had intended, then a new form of assessment could have been added to the EIA directive. It wasn't. It's there side by side, shoulder to shoulder with all the other receptors, environmental receptors. The second point is that I'm not sure it's right that no project would have a significant effect through greenhouse gas emissions when one is considering new airports and their use. We're considering roads. It's absolutely standard to consider when a major new road is built, whether that leads to an increase in transportation emissions. Interestingly, of exactly the kind that we are being told are effects of this project. They are assessed as effects of a new road as a matter of standard practice. So, not sure that that it's right that we're excessively limited.
It may not be limited to that. Wouldn't it include that?
I'm so sorry.
Wouldn't it include that? It may not be limited to that, but indeed your own scoping opinion expressed that view.
In the first instance, yes.
That it should extend to
Yes,
climate.
but was persuaded that they're not genuinely effects of the project on the environment. And that was Hill's position from the beginning, and was on reflection accepted. And the precise history for the reasons why are set out in Dr. Salder's witness statement, which is at least in part before the court. So,
could you just remind me where in 1995 there was a reference to climate, and then what changed exactly in 2004?
well, yes and no. In 1985, the first directive, in the same way as EIA is defined currently, and I think, if I may say, if this is an important matter, I ought to take the time to put something in writing. But in the way that the EIA process was defined, so in a much briefer way it was in 1985. And one of the important things that did change in 2014 was that in Schedule 4, paragraph 5F is new, and you'll see the directive in full in the supplementary bundle. But if it would be helpful to have a note of that 1985 reference to climate, I can readily provide it overnight.
It was Article 3 of the directive in 19.
Thank you. And before moving on, just to say that on the question of commercial purposes, I know that my learned friend, Mr. Elvin, will make submissions. I readily adopt what he says on the importance of the case Mart Gemiende, if I pronounced that right, and I won't take time on it myself. So I'm still on the project. It'll be apparent that the majority of the case law that's before the court dealt with the adequacy of one or two issues. One, whether the assessment failed to consider the operation of the project, and the other, whether properly understood the development formed part of a larger project. And it's my submission, I'm going to take this very fast, that the best cases to look at for the correct position on, or for guidance on those 2 points, are Abraham, which we deal with at 33 to 40 of our written case, page 153, and Friends of the Earth against North Yorkshire, with which we submit this case cannot be consistent with the ratio of that case.
So is someone going to take us to those in detail, or is this all we're going to get on submissions?
Well, if it would be helpful, I'll go to them now. I'm just running behind
Mr.
time.
Elvin are going to deal with it, but if you're telling us that these are the most important cases, it's a bit odd that we're not taking to them.
So, on those 2 points about the project, but they aren't the main issue here. The main issue here is who assesses the question of whether the ES is adequate, and how does one approach the question of indirect effects. So those are contextual authorities which, in my submission, indicate that the appellant's case cannot be supported, and I have dealt with them at some length. We have dealt with them at some length in our written statement. The North Yorkshire case is at 72 to 73 of our written case. I'll go to my third heading, and indirect effects. I start with the observation that there is no definition of indirect effects in the directive nor the regulations, and this reinforces the good sense of the Court of Appeal's approach. Equally, there's no good reason to treat indirect effects as a distinct, separate category from direct effects. The information gathering stage of EIA is designed to capture all effects of the project on the environment that are likely to be significant. And as to whether they're likely to be significant, the precautionary approach is taken. The legislation is clear that these effects may be direct, they may be indirect, they may be primary or secondary, they may be individual or cumulative. The aim is to capture all effects of the project, but equally if they're not effects of the project, they do not require assessment. Now, there is some relevant guidance on indirect effects in their identification, which, in accordance with well-established principles, it's not specifically relevant to an interpretation of the legislation, but it does shed light on the way it's been understood and is intended to work. But before I go to those, two platforms for the appellant's case, which I'd like to address head-on. First, that the combustion emissions were inevitable as a consequence of the extraction of the oil. This is not factually in dispute, and those arguing for policy changes so as to leave hydrocarbons in the ground make a serious political point. But as a platform for the appellant's legal point, it is in my submission unpersuasive. It's my submission that not all the consequences of a project are effects of that project. There has to be a sufficient causal connection between the project and the alleged effect for it to come within the phrase likely significant effect of the project. In short, my lords, my lady, not all consequences are effects.
I
illustrate,
simply don't understand that. They're two different words that mean the same thing, as far as I'm concerned.
so when one's considering the words in the EIA directive, I submit it's important to look at the purposes of the directive, which is to improve decision-making for the determination of an application for consent for a certain project. And that's why the focus is on the project itself and the effects of that project rather than all its consequences. I've got two examples. Many of the cases, well, one of the cases you were taken to by my learned friend, Mr. Willers, involved, the Bowen West case, involved a planning permission for a small waste facility in circumstances where there was to be a much larger application forthcoming. So the foot in the door point. To some degree, that latter development is a consequence of the earlier one. It won't happen without the earlier one, but it's not an effect of the earlier one, it's a separate project. Another example, the operation of a factory...
Well, if it were inevitably going to happen, then I would find it difficult to see why it shouldn't be taken into account. But I can well see that if it just helps to start as a basis for applying for the next permission, then that's not a strong enough connection.
So there needs to be a sufficiently strong connection. And
here the word inevitable is the key word, as far as I can see.
The operation of a factory, manufacturing cars which are reliant on petrol. Must the EIA of the development of the factory, the project being the building, the car being the end product, assess the greenhouse gas emissions of all the cars that it's going to produce over its lifetime? There's nothing in the case law to suggest that that is a proper approach to the legislation. We see nothing in the legislation or, importantly, the guidance to support that. And so I return to my earlier submission that it's really important to understand how EIA works, that it's an information gathering and assessment process designed to improve decision making for a specific project, and all of the consequences of that project. That process doesn't have to assess in the same way all the consequences of that project. The second platform that Madame Friend uses is the Scope 3 emissions that are described as indirect effects of the extraction in that context. Now, Scope 3 emissions, as a term, refers to that category of emissions which a company reporting its emissions may provide voluntarily. I'd ask your Lordship to go to Dr. Salder's witness statement at 1004. Because she considers the petroleum industry guidelines for reporting of greenhouse gas emissions. Let me just find, sorry, the...
Reporting in what context?
Thank you. So we're at 1004 from 16. She defines the Scope 1, Scope 2 and Scope 3 emissions in those footnotes. That's consistent with what's elsewhere in the bundle. And may I just highlight the very last sentence of the footnote 6. Emissions that derive from the use of petroleum products are under the control of product users and are most appropriately reported by them. So even for reporting purposes, and although the companies which extract hydrocarbons are required to report Scope 1 and Scope 2 emissions, even for reporting purposes, Scope 3 emissions, such as these, are thought most appropriately reported by those who are downstream. And a little further delving into the interesting subject of greenhouse gas reporting might make the reason for that clear. So, 19, I was also going to just touch on where Dr. Salder explains why Scope 2 emissions were not assessed. They are defined in very narrow terms solely to apply to those arising from the production of the electricity purchased off-site. And since Horse Hill were going to generate their own electricity, there were no Scope 2 emissions, so they were not assessed. Those would have been scoped in if Horse Hill had bought in its electricity as opposed to generating it.
But when you use
itself,
when you use electricity in your home, I don't think you create greenhouse gas.
no, but the generation of that electricity would, and it's that's the Scope 2 emission.
That's the footnote, isn't it, on the page we're on?
Indeed, yes.
1004, footnote 5, talks about what Scope 2 indirect emissions can include.
Indeed, I'm obliged for that clarification. And
So does that work that if electricity had been being imported to the site to make it work, the emissions costs of generating that electricity would be brought into the account for the plant.
Indeed
itself.
it would, yes. That would have had to be assessed within the EIA. Because the operation of the project requires the use of electricity. The electricity supplied is associated with those greenhouse gas emissions. So, I think that's enough on Dr. Solder's witness statement, but if your Lordship could go to 43, well, I number the documents, it's number 43, it's page 1021, introduced by Greenpeace, in fact, but containing an interesting definition of Scope 3 emissions. As they say...
What is this document?
This is... what's it described as? I'm so sorry.
Revised edition of the GHG.
Setting operational boundaries is A43. I'll come back on that question.
Looks like a European Commission document, is it?
It's not actually. It's guidance to those dealing with reporting.
What do you mean reporting?
It's a revised edition of the Greenhouse Gas Protocol Corporate Standard. As
Is this what companies have to include in their annual reports and accounts or something?
Yes.
And who produces this document?
I believe that the Greenhouse Gas Protocol is effectively an organisation in itself, but I'm not the person to ask. I'm dreadfully sorry.
Well, you're relying on it.
Well, no, Greenpeace are reliant on it, and I'm
Well, what are you referring it to as for?
yes,
if you're not
indeed,
relying?
and I should have found out more about the background to it. I'm accepting that the documents that help with reporting requirements are before the court. I will say that they're largely irrelevant, but I'm dealing with what's there and dealing with the argument that because these are Scope 3 emissions, which are described as indirect effects, they are therefore effects of the project for EIA purposes. And Scope 3 is defined here as an optional reporting category that allows for the treatment of all other indirect emissions. Scope 3 emissions are a consequence of the activities of the company, but occur from sources not owned or controlled by the company. Some examples of Scope 3 activities are extraction and production of purchased materials, transportation of purchased fuels, and use of sold products and services. So it's a broad category, is my first submission on this, covering all indirect emissions, save those arising from energy consumption. And in an EIA context, second point, it would not be appropriate to treat all Scope 3 emissions the same. Some of them are far more proximate to the project, have a far greater connection to the project than others.
Sorry,
And third...
where were you? I just couldn't find where you're reading from.
Oh, I'm...
When we went to 1031.
So, no, 1021 was where
I misheard you, I'm sorry.
Not at all,
Sorry.
my lord.
Down the bottom right.
And this is it was, to be brutally frank, it was for me a random document saying something about Scope 3, which helps us see how broad the category is. It's a catch-all for all indirect effects of the activities of a company, not a particular project or a project at all necessarily. The activities of a company, and it's catch-all for any indirect effect of their activities, and it is very, very broad.
So the bit we're dealing with here is use of sold products, basically.
Yes, yes. And so it's my submission, third point on it, that there's no support anywhere in the literature that for the proposition that all Scope 3 emissions are effects of the project of development. They are effects of the activities of the business. And if I can ask your Lordships, your Ladyship, to go through the bundle a little further to number 55, which is at 1153. This, I can say what this is because it's got a title. It's reporting guidance for local authorities. So local authorities are major corporations. They're required to report the greenhouse gas emissions associated with their activities.
So, and who produces this guidance?
I believe it's the Local Government Association.
I see. Right. Thank you.
And broadly, it's not a technical document. It is encouraging local authorities to report their Scope 3 emissions, as we see at the bottom of 1153. You will have a clearer picture that says of overall emissions, which will enable you to start to identify GHG reduction opportunities, set reduction targets, and to track performance. You will be able to engage value chain partners in greenhouse gas management. If I can ask the Court to turn to 1154 under Scope 3 emissions, I hope we can see 3 lines, well, just above the blue heading, Scope 3 emissions reporting relatively new, 3 lines down. The purpose of reporting is to help develop and support change. So the idea is that corporations tell the world what, in the broadest sense, emissions associated with what they do are, and then they can talk to their contracting partners, others with whom they do business, to try to put downward pressure on greenhouse gas emissions. That's the purpose of this document. And I am, I know, running out of time. There are, I'm going to take quite quickly the 3 other guidance documents which I had intended to take the Court to, and I hope it's helpful for me to do this because we have a 3,500-page bundle, and most of the documentation, we will say, is irrelevant. But these might be helpful in some small respects. May I therefore, bearing in mind the time, just give some page numbers? I'm obliged. So CV 891, the IEMA guidelines on assessing greenhouse gas emissions.
891?
CV 891, yes. These guidelines on assessing greenhouse gas emissions, it's what they don't say that's important. So I would invite your Lordships, your Ladyship, to read them in full. They show, they are guidance from the Institute of Environmental Management to practitioners on good practice in EIA, and you don't see the downstream emissions. You don't see in that guidance support for the appellant's case. I acknowledge this is a point of practice, not law, but it's an instructive read. Next, guidance for the assessment of indirect and cumulative effects. This is a 1999 document at CV 1018. Very briefly, it offers a definition of indirect impacts, but only one kind. Obviously, there's many kinds of indirect impacts, and illustrates the case where impact 1 causes impact 2. And I would like to reply to my learned friend Mr. Hahn on this point.
May I just ask a question? Do any of these deal with whether or not, as a matter of description or principle, whether or not the combustion of products which are mined or extracted from the ground are direct or indirect effects?
No, total silence.
None of them deal with that point.
So these and the third document I was going to take your lordship to is EC guidance on integrating climate change and biodiversity into EIA, which you might think was promising, but that too has no support for the argument within it, for the argument being made by the appellant in this case.
Where is that, please?
That is at CV 1047.
But none of them are actually directing their minds to the question we have to answer either, which is when one is concerned with the extraction of a mineral, whose usual purpose is combustion, that combustion is a direct or indirect effect of the extraction.
Yes, they don't answer that question.
No one actually addresses it.
But they're not addressing the question. But they are what there is, and they give some context to the submissions that I make about the process of EIA, the focus on the project, and in particular the need to put an appropriate boundary around the project when considering consequences. EIA cannot hope to assess the environmental impact of all consequences of development, only the effects of the project.
Yes.
So I come to the fourth heading, and I have 10 minutes on my time estimate, fourth of 7. It's not very good. I hope it's helpful to hear from me on the question of law or judgment. It's our submission that the authorities leave the question, what are the effects of the project, to the decision maker, subject to Wednesbury review. We cite the first instance judgment of Mr. Justice Sullivan in Blewett in our written case at 45 to 47. We submit that none of the many authorities and guidance documents before the court suggest a different or require a different conclusion to that which he...
How does that fit in with the approach that the CJEU has taken to answering the questions? In the CJEU judgments in Abraham or whatever, what is... They do seem to be answering the question, is this an indirect effect or not? And if they are or you say that's not the question.
No, that wasn't the question. The question before the court in Abraham was precisely as to the scope of the project itself and whether one assesses only the construction event or also its use. So the noise caused by aircraft were direct effects of the use of the project. So that was a misunderstanding as to the scope of project.
I can see your argument about the scope of the project and that the effects are only effects of extracting the oil from the ground and not what happens to it afterwards. What I can't at the moment see is how the answer to that question is a matter for one local authority to take one view on and another to take a different view. I mean, either you're right in that submission or you're wrong.
Yes, and the reason I'm right is that the circumstances of each case vary hugely. Every case is different. It's easy because this case has come to this court and we know it's a hydrocarbon case and that hydrocarbons are associated with emissions. It's easy to see that it's easy to think for a moment that or fail to appreciate the great variety in which these
so
decisions
what though?
are.
I mean,
well, that's why it needs to be for the local planning authority, because
it's not that sort of argument. I mean, your argument is one of principle, as I see it, that you, as a matter of law or construction, you only take account of the effects that are going to come about from what's going on in that place in Surrey, and not what happens when the oil is ultimately used. And if that's correct, then surely the same answer must be given by another local authority which has an application to drill oil in their territory, or for a coal mine.
No,
I just don't see how there's room for one local authority to take one view on that and another to take a different one.
But a different authority doesn't take a view on the same project.
But they take a view on the same question of principle as to what counts as a relevant effect.
And at that point, they will have to pay due regard to the principle of consistency in public law decision-making.
But how does that depend? The answer to that doesn't depend on exactly how many barrels of oil are going to be produced or how many stages there are of intermediate production. It goes one way or the other, the question, doesn't it? I just don't see what evaluative judgment is involved.
The senior president was very clear and persuasive in our submission on this.
Well, I haven't found it persuasive yet, so I'm waiting to hear what you have to say.
I'm taking comfort in his judgment, which is of course up for appeal. But in that he could not rule out the possibility. I mean, he went all the way with Holgate, almost to saying that in this case these are not indirect effects, and then he drew back from that, and we say he was right to do so in saying that he couldn't rule out the possibility that in a different case combustion emissions were effects of the project. And
so is that the paragraph 67 that you showed us before? Page 384?
Indeed. Which I referred to earlier. The specifics of such projects will vary greatly. So, my Lord Legate.
Your argument doesn't depend on how many intermediate steps there are, or whether whether the oil is going to be used in China or Africa or different facts like that. Your question is one of principle, I thought, on what kind of effects are relevant and what kind are not.
So I don't see those two positions as entirely distinct. So the County Council can... So the submission of law we make is that it's not for the court to define, in as it were, a hypothetical or abstract way what are or are not indirect effects. It's for the decision maker to decide on the facts of each case, subject to Wednesbury review, with all the power that review has for logical.
And what will be the evaluation that what will be the question that the authority are asking themselves in order to decide what they think the answer should be?
As the senior president said, it's the degree of connection between the event and whether the event that we're talking about and the project. And we need to remember that in this case, as I've said, the project can exist without the subsequent event ever happening. So it's not, although we know on the facts it's inevitable, it's not any part of the project. Whereas in Squire, for example, the poultry farm, this was a chicken farm, the poultry farm can't operate unless you properly dispose of the waste that chickens are producing. That indirect scope 3, we learn, effect was very clearly an effect of the project. Indeed, it was acknowledged to be an effect of the project, and then the quality of the ES was not considered sufficient.
So, but we're talking here about different circumstances involving development for the extraction of hydrocarbons. Obviously, the chicken farm case might be different, but I can't imagine at the moment how another oil extraction project is going to lead to a different consequence, whether you're either one way or the other.
But I think we have your submission. I think we must let you press on with the other ground you want to cover, because I'm afraid asked you lots of questions.
It's almost time up for me.
Please, if there are particular submissions you'd like to make on the other aspects of your case, you've been very patient answering our questions, but I think we must now give you a chance to develop the particular submissions you'd like to draw to our attention.
Yeah, I'm obliged. I'm going to deal with the question law or judgment, which was my fourth heading, and then the facts of this case. We need to go to the statement of facts and issues, which your ladyship has,
yes.
And the OR is obviously important. And then maybe I could put in writing something about the.
We've read your case.
The rest I will leave in writing. Yes, I'll just deal with this.
We've read the statement of facts and issues, so you may take all of that as something of which we have carefully read all of those. But
yes,
if there are particular matters you'd like to draw to our attention, please do.
As yet, we haven't gone to the Friends of the Earth and Heathrow, in which this very court endorsed the Blewett approach to the adequacy of an ES. And so I will take your ladyship to our case in order to do this quickly, to our case from 47, which is page 156. And there I actually set out, we set out the remarks of the Court of Appeal, which were affirmed by their lordships. And your ladyship know this is the airports policy case, familiar with the background, and it did specifically endorse the Blewett approach, which is the authority for the proposition that it's a matter for the adequacy of the ES was a matter for the judgment of the authority, and therefore subject to review only on Wednesbury grounds. And if I can read the underlined section from paragraph 136 of the Supreme Court's judgment. The authority must be free to form a reasonable view of its own on the nature and amount of information required, with the specified considerations in mind. This, in our view, indicates a conventional Wednesbury standard of review, as adopted, for example, in Blewett. A standard more intense than that would risk the court being invited, in effect, to substitute its own view on the nature and amount of information included in environmental reports for that of the decision maker itself. This would exceed the proper remit of the court. And that is the essence of my submissions on whether the adequacy of the ES is a matter of law or judgment taken from the highest authority, of course, this very court. And it fits, is my principal submission, which I sought to convey when going through the EIA process. It fits with the purpose of the directive, which is to help the decision maker make a good decision with full information on the environmental effects of a specific project. And given the time, I do regret that I had some brilliant submissions still to go to, but I'm going to sit down. I'm obliged.
Yes.
May it please the court. I think I'm timetabled to do half an hour now and half an hour in the morning. Can I begin my submissions by correcting a number of points that were made by Mr. Horn in her submissions by way of clarification as to what the position actually is. Firstly, so far as our agreement as to the effects of combustion and its accessibility, it goes as set out in the Statement of Facts and Issues at paragraphs 32 and 33. It doesn't endorse everything that the Senior President said in paragraph 71, but any of those matters that are listed. So you may say that makes little difference, but that is the limit of the agreement. Secondly, that agreement relates to combustion of the product, not the crude oil which is extracted by the project. I'll come back to that probably tomorrow morning when I'm dealing with the relevance of project and the intervening process.
So the agreement deals with what did you say?
It deals with the agreement that it is likely that the oil would be used for the production of something would be ultimately combusted as fuel.
Right.
And that there is a general ability to estimate. It's paragraphs 32 and 33 of the Statement of Facts and Issues. That's the extent, not what Mr. Hunt suggested. Secondly, it is not agreed, as she suggested, and I think this was picked up with Mr. Willers, that it's not agreed that downstream emissions from burning fuel derived from oil is a material consideration. That would be inconsistent with our primary case. What was in fact said, I'm sorry, the microphone's out of the way. What in fact the position was is this was a balance between energy and minerals policy, that is to say the extraction of fossil fuels for the transition to net zero, which is in government policy and government energy policy, and balancing that against climate change issues. That was what we accept as a material consideration, that is the balancing of those policies, not the inevitability that downstream emissions should be treated as an indirect effect, which I hope is a tenable and not a medieval assumption. The benefits, therefore, relate to the supply, maintaining a supply of hydrocarbons in the interim while the transition to net zero is made by 2050, and that's clearly set out in government policy, and you'll find that set out in the officer's report at some length. The officer's report deals with the balancing of need and climate change. So much paper. I'll give the references tomorrow. It's the officer's report is largely taken up with need for the hydrocarbons and then putting them in the context of the government's policy on climate change.
I think it's page 493.
That sounds familiar, my lord.
Let's go to the core volume.
I will be coming back to that briefly in any event. The
496 looks at the policy.
It runs over about 5 or 6 pages where it runs through energy policy and climate change policy, how net zero has developed and gone from the 80% to the 100% cut in emissions, and then how that all balances out. That was clearly a material consideration because the local authority had to grapple with the balance between the tension of climate change against the tension of the need for energy supply in the meantime.
But they don't need to carry out that balance, they don't need to know how much emissions would be made by this oil.
Correct, my lady. Next point is the other directives that my learned friend pointed to in passing in the directive, in fact, relates to the Habitats and Wild Birds directives because there is a need for coordinated procedures because there are also assessments called an appropriate assessment under the Habitats Directive and the Habitats Regulations. You'll see this in Article 2.3, CV 1234, Article 3B, CV 1235, and the coordinated procedure that the directive calls for to ensure that the environmental impact assessment is coordinated with the ecological assessments relating to habitats and wild birds. That those provisions, in fact, are coordinated in national legislation in Regulation 27, which isn't in the bundle. I'm sure the court doesn't need providing with a full set of regulations, but it's Regulation 27 for your notes.
Which regulation?
Regulation 27 of the 2017 EIA regs, not in the bundle.
That deals with the coordination of this process with the habitats.
Indeed. So that issue is clearly just a matter of ensuring there is consistency and no duplication of effort where it's unnecessary. The next point is that the issue of climate has been in the directive from the beginning, from the original 1985 directive, and I rudely interrupted to give you a reference, which was Article 3. In fact, it's easily found without providing you with yet another document. The Abraham case, Article 3 of the original directive is quoted at paragraph 4 of the judgment, page 1624 of the bundle. And you'll see it refers to climate, as does in fact Article 3 of the current directive. The directives also, in what is now Annex 4 or Schedule 4, referred to climatic factors. Can I give you the references? If you require copies of the relevant paragraphs, they can be provided. 1985, Annex 3, paragraph 3. Annex 3 became Annex 4 in the next iteration of the directive, and the same language appears in paragraph 3 of the 2011 directive. One might be forgiven listening to my learned friend, Mr. Hon, thinking that the 2014 directive was entirely focused on climate change. It wasn't. The 2014 directive, which begins at page 1263 of the bundle, was there to tighten up and allegedly to simplify the EIA procedures in many respects, of which climate change was only one. Can I just show you briefly preambles 1 and 2 on page 1263, and then a whole list of matters in the preambles, climate change coming in 2 of the 17 preambles. Paragraph 7, 1264, where it's one of the matters which have become more important in policy making, not the only one. And then paragraph 13 on 1265, where it says climate change will continue to cause damage to the environment, etc. And in fact, the specific amendment made by the 2014 directive was to introduce the issues such as vulnerability of projects to climate change, which, if I can show you, is on page 1272 of the 2014 amendments, which introduces into Annex 4 of the directive a new paragraph 5F. And you'll find that in the consolidated version 5F in the bundle. So climate and climate change matters are not new to the directives. They have been there all along. Of course, emphasis has increased as time has gone on for reasons which will be obvious to the court. Next point relates to the discussion of Scope 3 emissions. Scope 3 emissions is not an EIA concept. What I say about Scope 3 emissions is it's really a red herring for the purposes of this appeal, because it's a matter for corporate accounting of emissions. The GHG protocol is based on a worldwide organisation. It is used extensively by the American EPA. It's also used in corporate returns, but it's not tied to the concepts of direct and indirect effect in the directive. And so my simple submission is, we're not dealing with Scope 3 emissions, we're dealing with indirect effects under the directive, and the one does not inform the other because it's a different background and a different function. I'll say no more about it. And the concepts of direct and indirect effects are common to all EIA projects. They have been in the directive and the regulations from the beginning, and they must fall, as my learned friend accepted, to be treated the same wherever they appear in the directive. It also therefore follows that if you are to give a very broad approach, which we say the appellants are doing, that broad approach must be applied to all the projects, particularly in Schedule 1. I'm going to show you in a moment some of the other Schedule 1 projects, just by way of example, because there is a law of unintended consequences by taking the broad effect that my learned friend sets forward as to what it will do generally. This is something which I will deal with tomorrow because it's an issue that the Irish Supreme Court grappled with in the Kilkenny cheese case, which was a concern of overproduction or additional production of milk and the production of methane via those producing the milk. I'll come back to that tomorrow. But the concept of direct and indirect effects must apply if it has a wide meaning to all EIA development, Schedule 2 or Schedule 1, and it can't simply be a concept which is to be defined by reference to fossil fuels. Perhaps useful to go to the directive now. Doesn't matter whether one looks at Schedule 1 of the regulations or Annex 1 to the directive, but perhaps Annex 1 to the directive is as convenient as anything. If the court would please go to 1245. Quite apart from noting that crude oil refineries are an Annex 1 project as well, paragraph 1, you have thermal power stations, paragraph 2, paragraph 4, smelting of cast iron and steel and non-ferrous crude metals. You also have chemical installations for the production of various forms of organic and inorganic chemicals. The concept of downstream and potentially upstream indirect effects is a very broad one when you consider the processes involved. And sometimes you're dealing with raw materials, sometimes you're dealing with the production of products. And that's a matter of distinction which we say ought to be borne in mind here, because it is the combustion of a product which is the result of the use of the materials extracted here, the oil, and not the use of the oil itself, with which you may contrast other matters. For example, thermal power stations, of course, their emissions may directly impact on climate change, or at least indirectly. Just as there are emissions which are accepted to have climate change consequences in terms of this development, and which are considered in the environmental statement. For example, the production of natural gas is a byproduct of the extraction of the oil. But the point I'm making is that the scope for indirect effects, both upstream and downstream, is considerable when we look at the various categories falling with Annex 1 and Annex 2.
Presumably you would say, or would you say, that even with the crude oil refinery, they would be able to make the same argument as your client makes, that yes, we're refining the crude oil and selling it on to people who will burn it, but still their burning it is not part of our project, and so not an indirect effect of what we're doing in our project.
I'm not sure, my lady, I would go that far, because it's a question of how intimately associated the effects must be, which is a matter for the court. In this case, how intimately associated must those end-use effects be with the project?
I thought you said it was not a matter for the court, that it's a matter for the local planning authority.
That's only my second line of argument, is to agree with the Court of Appeal. My first line of argument is to take a point of law, having regard to what my Lord Legate said, which is why I've got two ways of putting the case. The Wednesday approach I put only as the second line. The first line is much more in line with what Mr. Justice Holgate said at first instance. Where was I? Yes.
That is a clear difference between you and the first respondent then.
Yes. Yes, I'm reverting to Mr. Justice Holgate as my primary approach. And I say this, is that there is clearly a difference when looking at the Annex 1 projects between those which have a direct product and those which are producing raw materials for another product. For example, with the smelting of iron and steel, how far does the untrammeled exercise of the application of indirect effects suggested by my learned friend, only by reference to the threshold criteria of likely significant effects which are capable of assessment, how far does that require huge difficulties and uncertainties in terms of assessment? And where does it get anyone at the end of the day, bearing in mind you're trying to understand the implications of a specific development project? this gives rise to another point of contention, if not correction. My learned friend, in her opening submissions, made it clear that the greenhouse gas emissions she was dealing with, the indirect effects which she says they ought to be categorised now, is a much wider than local effect. There's a difficulty with that because there is a requirement to assess transboundary effects, and there is a specific procedure which then kicks in under Article 7 of the directive, which requires where there are transboundary effects, which are likely significant effects, which by definition they must be if they're being assessed, requires consultation with every member state under the directive who may be affected. That has been translated post-Brexit into the regulations, again, not before the court, but it's regulations 58 and 59, and it turns member state into EEA states. So anything in the European Economic Area, any state which is likely to be affected by transboundary effects must be consulted and send copies of the environmental statement, etc. So the consequence of my learned friend's open-ended submissions are to say that you have an impact which is potentially global in effect, but certainly brings in potential for transboundary effects and the potential need, even on a local project such as this, for transboundary consultations. And it isn't just the factory next to the border, it goes rather wider than that because of the nature of greenhouse gases. The next point is that much reliance has been placed on a series of cases which in effect are about what the extent of the project is, not what the effects, indirect effects of the project are. We've dealt with it in our case, but into that category I'd put Abrahams, Ecologistas, Commission against Spain. They are, and indeed two of the Irish cases that are in the bundle.
Sorry, can you just
I'm sorry.
say what the submission was again?
Yeah, they are about the extent of the project and perhaps more colloquially project splitting than what an indirect effect is. So in Abrahams, what had been assessed was only the effect of the physical works and not of the use of the works, i.e. the nature of the project, the extension to the airport. In Commission against Spain, the applicant had tried to split up a rail project into a number of segments, so you hadn't assessed the overall effect of the improved train system. Ecologist is the same, except for motorway improvements. There are two Irish cases which raise similar matters. They're dealt with by the Supreme Court in Kilkenny Cheese, but I'll just touch upon them. One is at 3131 of the bundle. It's the Friends of the Irish Environment. It's referred to as Eldonderry by the Supreme Court in the Kilkenny Cheese case. That was a case where a power station was being consented, and the question was whether peat being produced from a peat bog was also an effect of the project. And in what the court said is, well, since the two peat bogs in question were dedicated to providing peat for the power station and that there was a private rail link to ensure the peat got from the peat bogs to the power station, it was all part of the same project. Ditto the Fraymore case, which is at 3254. That was a wind farm with a grid connection, and the court held, well, the grid connection was an integral part of the project and should have been assessed. So the whole raft of cases which are not actually dealing with the effects of the project as opposed to the effects of the project properly understood. The issue of commercial purposes, which I will grapple with now, and my respectful submission is that Lord Justice Moylan relied upon the existence of that phrase to depart from the view of the majority, and he clearly saw that as of some significance. Whether it is to the court's another matter. But the only point I wish to make is that he misunderstood that that had any real significance as opposed to the extraction of oil and gas, which is the project. And the reason for that is in the supplementary bundle, which I think is also referred to as Volume 3. It's the Marktgemeinde Straßwalchen case, been practicing. Page 75 of the supplementary bundle, or volume 3, as it's also fondly called. And what both the Advocate General Cocotte, and the court said was the use of the word commercial purposes was to merely distinguish it from research purposes. And you'll see that at paragraph 26 of Advocate General Cocotte's opinion, page 85 of the supplementary bundle, and paragraphs 22 to 23 of the CJEU's judgment at page 99. And all we say is it's wrong to put any weight on that phrase because it's just performing that particular function. Commercial purposes did not, as Mr. Hon seemed to suggest at one point, come in 2014 as a result of the increased emphasis on climate change. It was in the 2011 directive before amendment. Now, as has already been indicated, there is little guidance from the EU and certainly no guidance from the CJEU on this specific issue before the court. There is one small piece of guidance which the court may or may not think takes the matter further, but since it is actually relating, it is Commission guidance on hydrocarbons, it is at least relevant to take the court to it, so at least to know what limited guidance there is. It's at 1045 to 1046 in the core bundle. It's called Annex, Guidance Note on the Application of the first version of the directive to projects related to the exploration and exploitation of unconventional hydrocarbon. It's dealing with fracking rather than ordinary hydrocarbons, but there's a point there which I'll show the court. Please don't ask me what it's an annex to. I spent far too much time over the weekend trying to find out. It's simply on the Commission's website as current guidance. It doesn't actually say what it's an annex to. In fact, it's Annex 2, apparently, according to the Commission's website. Page 1046, third bullet down, refers to this environmental information, that is, that comes in the environmental assessment, should assess the likely significant direct and indirect effects of all related associated works and sub-activities intrinsically linked to the implementation and purpose of the unconventional hydrocarbon project, e.g. new infrastructure necessary to serve the project in question, storage facilities, etc. That's about as much as you get from the Commission. It is interesting and potentially relevant that it seems to think that an intrinsic link is necessary, and I'll come back to that and discuss the issue of inevitability when I come to my submissions in the morning. There is also, and this is possibly of less assistance, in the document my learned friend Mrs. Townsend looked at in brief, which is the next document in the bundle, which is the guidance on integrating climate change into EIA. There are references to both direct and indirect effects on page 1049 and 1050, which I suspect don't take matters much further. Indirect effects on 1050. Effects or impacts that occur away from the immediate location or timing of the proposed action, e.g. quarrying of aggregates elsewhere in the country as a result of a new road proposal or as a consequence of the operation of the project. See also secondary effects. I'm not sure that that really assists, but I thought you ought to see at least the two bits of Commission guidance which bore, even if indirectly, on the point. In the 3 minutes left, let me just summarise my position on indirect effects. Taking my cue from the Irish Supreme Court in Kilkenny Cheese, which I will deal with in more detail tomorrow, but it's at page 1717 and following. In particular, see the issue at paragraph 7 on page 1719, and then the issue called Part 4, the challenge based on the EIA directive. You'll be pleased to hear it's actually dealing with the same legislation, page 1731, running to 1752. Part of it's grappling with the facts as found by the planning board, but it then deals with matters such as the approach to indirect effects. And my submission is this, that the approach adopted by the appellants is to take a very expansive and open-ended approach to the meaning of indirect effects, and doesn't seem to connect it other than by relying on the statements that are agreed in paragraphs 32 and 33 on what they call inevitability. Inevitability, in my respectful submission, relates to the fuel, the product of the refining process, not to the extraction of crude oil. That crude oil cannot be used for the purposes for which there is to be combustion until it has been through effectively a manufacturing process, the refining process. The difficulty...
But, I mean, what else can the crude oil be used for? Other than
Well, no, I appreciate that, my Lord. I'm not suggesting, and it would be inconsistent with the agreement in the Statement of Facts and Issues, to say that it wasn't likely to be destined for the production as fuel, but it can't be used directly itself. It has to go through that separate process, and it's not just some intermediate intervention. It's a new process which is also an Annex 1 Schedule 1 project, which is the refining of oil. And the quantities which, in paragraph 1 of Annex 1 and Schedule 1, which trigger the requirement for assessment, are the same quantities of oil which trigger the assessment of the extraction of oil and gas under paragraph 14.
And so that's, you're out with the scheme then, because you say these are not indirect effects, and that's that.
Yes, that's my essential case. And I'll, as I say, deal with certain aspects of it tomorrow if that's convenient, particularly my Kilkenny cheese case. And I say my Kilkenny cheese case, you'll see it's not referred to in our case at all, and I'm grateful to West Cumbria Coal for drawing our attention to it.
Thank you very much. Then we'll, that's convenient. We'll adjourn until tomorrow morning.
Thank you very much.